to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all.
Many of you have been with us before and have heard the familiar announcements, but please just remember not to bring any food or beverage other than water. Please silence your cell phones, and if you are speaking publicly to the commission, we ask that you speak loudly so that our recording equipment captures your statements. I do want to let you know that in a few minutes you'll see our newest commissioner, Ashley Kuhn, slip in, so don't be surprised. This was her first meeting, and she didn't make it in the most direct route to the first DCA, but she'll be here very shortly. But I think that we can proceed now with the approval of the minutes. I'd entertain a motion to approve the meeting minutes of January 19th.
Motion.
Second.
Moved and seconded. Is there any discussion? All those in favor, please indicate by saying aye.
Aye.
Any opposed? The minutes are approved. We are going to take a little detour in our agenda to start off with so that we can accommodate the schedules of some of the others that are present for this item. And if there's no objection from the commission, we will move the matter involving Ken Hagan's petition for attorney's fees, item 15-215, if I read that correctly, to the beginning. So I'll give everybody a second to catch up to item 6A in your agenda. Do we have any handouts in this matter?
Madam Chair, we received correspondence from the complainant, I think the day before yesterday. We have copies of it. As you'll recall from last meeting, we had late filed documents. Our rules don't provide for that. But if any member of the commission wants to receive those documents, they can request it, and we do have copies.
Let me just, by way of background, remind everyone, this attorney's fees case filed by Mr. Ken Hagan was the respondent in complaint number 15-215. Mr. Hagan's petition seeks to have the complainant, Mr. George Neiman, pay attorney's fees and costs following the dismissal of the complaint against Mr. Hagan. At the last meeting, you will recall the petition was dismissed as legally insufficient with leave to amend, and today we have before us the amended petition. So just recall that at this stage, if the petition is denied, the case will be dismissed. If the petition is not denied, the matter will proceed to the Division of Administrative Hearings for a hearing. Are either Mr. Hagan or Mr. Neiman or their counsel present? Thank you. Anyone else present in this matter? We have copies of the file and of the staff's draft of an order dismissing Mr. Hagan's amended petition as legally sufficient. As Ms. Doss explained, we do have other correspondence, but hearing no request for it, we will not entertain that. Yes, Mr. Cox.
I would like to see it.
Okay. Is there any discussion? Mr. Cox has basically asked. I don't think it
Yes,
needs to be in the
please.
form of a motion.
Pretty please.
2 pretty pleases is enough. Any discussion on that? Hearing no objection, then would you please proceed with passing out the material? Before you take a look at this, can I ask you to just, like your children, turn around, put your paper down, and Mr. Schaefer, is there anything that you want to say about this document before we proceed?
No, I think it speaks for itself.
Okay, thank you. You may turn your paper over. Mr. Schaefer is going to summarize the staff recommendation on the petition after you've had a chance to review this. Then we will hear from Mr. Levine, followed, but I don't think there is anyone here on behalf of the complainant. The parties, as you know, Mr. Levine, we'd ask you to limit your remarks to 15 minutes, and after that, the commission members are free to ask questions. So we'll take a few minutes on this document. Mr. Schaefer, you ready to proceed?
Yes, thank you, Chair. In my opinion, this amended petition brings nothing substantive to adequately plead the elements of the fees and costs statute. I am recommending that it be dismissed. I just want to briefly review that statute with you. It's found in section 112.317, subsection 7, and it's very specific about the circumstances where fees and costs can be awarded. Requires the party petitioning for fees to allege these elements in their petition for you to send it to DOA. First, that the complaint contains false allegations. Second, that the false allegations concern material facts. And third, that the false allegations were made either knowingly or recklessly at the time the complaint was filed. I'd like to briefly walk you through my analysis of the arguments in the amended petition, but I first want to just make some general background comments on this statute. It's a very exacting law. The legislature intended it to be difficult for an ethics respondent to obtain fees, and that's why the statute contains elements that are so challenging to allege and then to prove. And the reason for that is you don't want to chill potential complainants from bringing ethics complaints based on the fear that if during the ethics investigation their allegations are found to be false, that they'll have to go through a very costly DOA trial on fees. The fee statute needs to be strictly construed, frankly, so that people across the state are not frightened to file ethics complaints before you. And because of that, it's not surprising that it's so rare for you to actually send a fees petition to DOA. It happens. It's happened recently, but it is rare. Now here, according to the amended petition, Mr. Neiman, the complainant, brought his complaint based on information that he learned from an investigative journalist working for a television station in the Tampa area who was covering a story on Commissioner Hagan. The amended petition alleges that information was credible enough to spark an exhaustive criminal investigation based on those same allegations for multiple law enforcement agencies in the Tampa area. Now, I think you should just consider that the allegations are based on information from a credible investigative journalist and that they were credible enough to spark a major law enforcement investigation when you're weighing whether Mr. Neiman was reckless in bringing the complaint. Now, if you look at the content, the arguments of the amended petition, even accepting them all as true, I don't believe they demonstrate Mr. Neiman brought the complaint knowing it contained false allegations or with a reckless disregard as to whether it did, which is an essential element of the fees and costs statute. The first argument is that Mr. Neiman based the content in his complaint on information that he learned from that news reporter. The amendment claims it's reckless for him to base his complaint on what he'd heard from others. Now, Commissioner Hagan raised this exact same argument, including the same language, in his initial fees petition, which you've already dismissed as insufficient. And I would remind you, again, there's no requirement in the ethics rules or the statutes requiring that a complaint be based on personal knowledge. You often accept complaints based on news reports or based on secondhand knowledge. In fact, our rules provide that an ethics complaint can be based on hearsay. To facially plead the elements of the fees and costs statute, this petition would have had to substantively allege Mr. Neiman knew that news report was false or had reason to question it, but brought his complaint anyway. And no such specific allegation is made in the amended petition. And the petition next argues that there are 3 other ethics complaints containing similar allegations that were filed against Commissioner Hagan at the same time as Mr. Neiman's. The petition argues this shows Mr. Neiman and those other complainants were conspiring together to bring their complaints. But whether other complaints were filed based on similar allegations is not really relevant to, in my opinion, to whether Mr. Neiman knew or should have known the allegations were false when he brought his complaint. Just shows that other private citizens shared some similar concerns about Commissioner Hagan. I will say, too, it's curious that while Commissioner Hagan strongly emphasizes in his fees petition that the other complainants brought allegations almost exactly the same as Mr. Neiman's, he hasn't moved for fees against any of those other complainants, only against Mr. Neiman. The amended petition next claims Mr. Neiman should have more carefully researched certain allegations that were found to be false during the ethics investigation. Claims he should have made public records requests for meeting minutes from the county commission and records from the Division of Elections before filing his complaint. But the amended petition does not allege Mr. Neiman knew those allegations were false, only that he should have verified them before bringing the complaint. Commissioners, there's no requirement in the ethics statutes or the rules that a party must exhaustively research their claims before filing an ethics complaint. We don't want to stifle complainants by having them conduct an independent investigation on their own. That, to a certain degree, would supplant the investigative role of this commission, which, according to the Florida Constitution, is to look into and investigate possible ethics violations to determine their truth. Now, here again, it appears Mr. Neiman based his complaint upon information and statements concerning possible ethics violations that he had learned from an investigative journalist who was already researching those claims, a local TV reporter. He then filed an ethics complaint asking the commission to look into the allegations for their truth. And frankly, that's exactly what the commission has been asked and designed to do, especially when the allegations are coming from a credible news source. And there are two other arguments in the amended petition. First, that Mr. Neiman should have waited for the results of a criminal investigation into the commissioner's conduct before filing the complaint. That implies he was reckless in bringing the complaint before the criminal investigation ended. Apparently it's being conducted by the Hillsborough County Sheriff's Department, the State Attorney's Office, and the Florida Department of Law Enforcement. But that other investigation would have been into criminal statutes, not violations of the ethics code. Plus, the fact that numerous law enforcement agencies found these same allegations credible enough to launch a major investigation works against the claim that this complaint was recklessly filed. And finally, the amended petition lists 4 instances between 2009 and 2014 where Mr. Neiman criticized Commissioner Hagan's performance as a county commissioner in various emails and in newspaper articles. But it's unclear how those criticisms are relevant to any of the allegations in this complaint, and therefore I don't believe they're relevant to show Mr. Neiman knew or should have known the allegations in his complaint were false. So for those reasons, I don't believe this amended petition corrects the deficiencies in the initial petition. In my opinion, it doesn't raise any substantive, credible allegations explaining whether Mr. Neiman knew his complaint contained false allegations or acted with a reckless disregard as to whether it did. So I'm recommending that this amended petition be dismissed.
Thank you, Mr. Schaefer. Mr. Levine, you've got 15 minutes.
I won't take that long, Madam Chair. Madam Chairman, member of the Commission, Madam Executive Director, Mark Levine and Stivers here in Tallahassee on behalf of Commissioner Hagan. First, thank you for moving me up. I'm supposed to be at a 3 o'clock meeting in Atlanta, so I got to move a little here.
I wonder you're not going to take your 15 minutes.
I'm not going to take my 15 minutes. I would point out to you that all of the allegations made against Commissioner Hagan were not found sufficient. There was no evidence to support any of those allegations. We believe, and we believe we have pled properly, that Mr. Neiman filed with reckless disregard, did not check his facts, which he could have done. He did not examine public records, which indicated to the contrary, and he could have done. He takes the tip of a reporter, which now we understand to be the case, other than it being a news story, and it did not come from a news story. And I will tell you that the reporter in question is not a creditable source in this particular case. And we believe he was clearly on a mission to get Commissioner Hagan. I can tell you, pled a lot of pleadings in courts, things of that nature. I've never had such a difficult time in pleading as I have with this particular complaint. There's no question that I have pled the elements. The elements are there. Generally, when you plead the elements of an offense, it is then your obligation then is to move forward to prove those elements, and that is our burden to go forward to prove the elements. It is not, in my opinion, the position of this commission to take a look at this point about whether I can prove those elements. I cannot come to you unless I lie to you in an amended petition or an original petition and make statements of which I believe I know now without substantial proof. So what I've said to you in this amended petition is what I've pulled off of public records and social media, and clearly the basis of the complainant's knowledge, his feelings, his intent are not present on the face of his complaint. He did not make adverse statements against his interest to the investigator with the Commission on Ethics. The pleadings cannot get into his head. I cannot determine what Mr. Neiman was thinking and what he did and whether he did it recklessly without being able to take his deposition. There's no pre-discovery issues in front of this commission nor generally in any circuit court case. I'm sorry? Oh, okay.
Good.
So we know from what I have done in the amended complaint that Mr. Neiman calls Commissioner Hagan a crony. He pulls his family in the matter and then calls him a liar. Now, those things you may have a right to do with your public officials. I think we still have a First Amendment in this country. But those types of things that evidence his attitude and his feelings towards Commissioner Hagan are the types of things that I should be able to get into when I set Mr. Neiman for a deposition under oath. Those are the types of things about why he did this, how he did this, what he reviewed. The criminal investigation was not the result of a news story. It was a result of some political activity in the Hillsborough County area that caused not only Commissioner Hagan, but several other commissioners to be scrutinized in regards to how they do business on their cell phones. That's what it all stemmed from, because I represented a couple of them. And that's how it came about. All of this was investigated. Mr. Neiman could have read that report. It's several hundred pages long. I've got a copy in my office. It was available to him. And he would have known then at that time that those allegations that he made or was going to make are absolutely false and without any basis in law or fact. Did he do that? No. That, to me, is reckless disregard. He did not take it upon himself. The issue of whether my complaint rises to the level of an award of fees, I do not believe at this juncture is within the province of this commission. I believe that it is within the province of an independent administrative law judge. I don't prove my case, administrative law judge is going to give you a recommended order that says Levine didn't prove his case. You'll adopt that. If I prove my case, then I guess we can debate whether you adopt the recommended order or not. But to prohibit someone like Commissioner Hagan or any other public official from moving forward in a positive fashion to determine what the intent was. If we required in a complaint for an individual to state their intent, maybe I could plead it better. That's not required. It's never going to be required. It's not reasonable to make them required. They state their allegation. It's determined by your director as to whether it's legally sufficient, and if so, you move it to an investigation. That's proper, and that's what you should do. That does not thwart the public from making their complaints about public officials and others under the auspices of 112. To stop this proceeding at this procedural point, I believe is an affront to the good men and women who are subject to recognition under 112. You do not give them an opportunity to pursue avenues that are clearly available by law to them. They have a right to seek their justice, as Mr. Neiman had a right to seek his, for being wrongfully and negligently accused of public corruption. Neiman did not even consider the findings in the criminal investigation. And I can tell you the criminal investigation was extensive. It was obviously politically motivated, as most are. Okay? That's the way our society is. That's what happens. Look at what's going on several blocks away downtown with investigations and things. It is what it is. I don't propose to you to change that. What I propose to you is that people who are wrongfully brought into that and are exonerated from alleged bad behavior, to give them the right to come back and do what is right and just for them. I respectfully request that you allow the petition to move forward so that I can go to an administrative law judge and do the discovery that's necessary to make my case. Be happy to answer any questions.
Thank you, Mr. Levine. Are there any questions for Mr. Levine or Mr. Schaefer? Mr. Cox?
Yes, sir, Mr. Cox.
So I'm curious, you mentioned about the news reporter not being credible, and that was part of the problem for Mr. Hagan. Are you taking legal action against the reporter?
That has been considered, but I'm not at liberty to, it would not be what I would do personally, because that's not the kind of law I practice. There are issues in respect to this particular reporter that have been ongoing for months and maybe a couple of years. So there has been discussion about that type of thing, but I can't tell you at this point that there was any positive affirmative action moving forward. It's not the first time that we've been in this situation with this particular reporter.
Are there questions for Mr. Levine? Mr. Levine, if you'll just pause 1 second, I have a question for Mr. Schaefer, and if you'd like to respond to it as well,
I will.
you may. Mr. Schaefer, this calls into question to me the burden of the complainant to evaluate the credibility of the news source. I mean, what is our expectation, and how are we going to determine whether the complainant did what he was supposed to do going forward in order to make a determination of credibility?
Well, that's a good question. I think that, as I said before, I think the question here about whether or not the reporter was credible is not the key question that you need to be looking at. You have to be looking at whether or not the complainant knew that the report was not credible, the information was not credible at the time he brought the complaint, or had reason to question it. That's the particular question that's before you all. Now, I think your question too touches on what the degree of specificity should be in the fees petition itself. And I remind you, the rule says that the elements of the statute have to be pled with particularity at this stage of the proceeding, at the sufficiency stage. Now, at the last meeting, Commissioner Norris asked me to take a look at the pleadings for civil fraud in Florida, which also deal with that requirement that the allegations be pled with particularity. And I did some homework on that. In the case of civil fraud, it means that when you're pleading, you have to identify the specific fraudulent representations and allege why they were false. You have to look at the circumstances around it then and put that all in your pleading document. I think in this particular case, I think to have a facially sufficient fees petition, the commissioner have had to have alleged that Mr. Neiman knew or had that the report was not credible or had reason to doubt it, but brought his complaint anyway. That is the requirement, in my opinion, to be able to plead with particularity the elements of the statute.
It's a bit of an unfair question with that disclaimer. If this was, using your comparison or Commissioner Norris's to a civil fraud count, if this petition was in front of a circuit civil judge, it would probably meet the standards that are required to get by a motion to dismiss. So if you could just encapsulate one more time why this commission is really operating from a different set of standards in evaluating the motion to dismiss than the circuit civil judge would be.
Well, again, I think that the rule states it has to be pled with particularity. And I don't want to be beating a dead horse here, but I would direct you back to the fact that all we really have here is a petition that alleges that you had a news report that was not credible and that he based his complaint on that news report. That does not show that he knew or had reason to doubt the content in the news report, which is what we would need to find this complaint or petition sufficient, in my opinion.
Mr. Levine, you don't have to respond, but you're invited to.
Let me just say this. I believe that I pled it facially. Again, I've been doing it a long time. I've never had as much difficulty. I've said more than just it was based on a news tip from a reporter. I've said more than that. I've said that he did not do his due diligence. He made allegations that just by looking at the public record or asking the county administrator, I mean, the allegation that Commissioner Hagan engaged in behavior that was inappropriate under 112 by voting for Parsons Brinkerhoff's contract when in fact Commissioner Hagan never had the opportunity to vote on that contract. Mr. Neiman goes to these commission meetings. That was a decision made by a county administrator without a vote of the county. That allegation was prominent in this complaint. Mr. Neiman knows better, and it's damaged Commissioner Hagan. It's been in the newspaper, and the reporter continues to pound on it. And I believe that I have sufficiently pled it to get by a motion to dismiss so that I can go forward and try to prove my case. It's only when I get into his head and the others involved that I can be able to show the absolute elements beyond proof by a preponderance of the evidence that these things occurred. I should have that opportunity. Thank you, Madam Chair.
Thank you. Any other questions for Mr. Levine?
As being the personal knowledge of the complainant, right? And so if the matters that are not your personal knowledge is what is the basis of your complaint, do you not see that there is some duty to question whether or not you know that that's true?
From what I'm understanding, you're asking me then, whenever we have a complaint that's not based on personal or direct knowledge, we're going to be holding the complainant to a higher standard than we would to any other complainant. And
I would, in fact, not to argue with you, but in fact, I think we don't. That's my point, all right? We evaluate the complaint based upon the allegations of the complaint as to whether or not it's sufficient. Why is the standard different now in the public official who's been accused rendering his complaint authorized by statute to seek the redress of attorney's fees?
Well, in response to that, I do think that there's a difference in the pleading requirements for attorney's fees petitions and ethics complaints. And if you would just give me a second here, I can quote that for you. Okay, I'm looking at Rule 34-5.002 subsection 1, which sets out the requirements for a legally sufficient ethics complaint. And it says here, complaints need not be as precise as will be required by the rules of civil procedure in a court of law, and shall be deemed sufficient if the complainant under oath, upon knowledge or belief, alleges matters which, if true, may constitute a breach of public trust. And it goes on to state, a complaint shall not be insufficient because it is based upon evidence which would be hearsay evidence in a court of law. Now, if you would contrast that with Rule 34-5.0291, subsection 2, which talks about petitions for attorney's fees, it says such petition shall state with particularity, which I think I've already described as a higher burden, the facts and grounds which would prove entitlement to costs and attorney's fees. So I think in our rules there is a distinction between the pleading requirements in an ethics complaint and the pleading requirements in an ethics petition, in a fees petition.
I don't disagree with that point. But what I disagree with is the standard that you're applying to at the pleading stage for the petition for attorney's fees. I mean, we have approved petitions. Every case is going to have its own facts and its own different nuances, but we've approved petitions for attorney's fees that are facially the same as the petition for the attorney's fees in this case.
I would disagree with that. I think in the other cases, since I've been on the commission, where you've approved an attorney's fees petition and found it sufficient to send to DOA, there have been outside circumstances that showed that the particular complainant knew the allegations in the complaint were false, or at least had significant reason to doubt them, because they were citing a newspaper article perhaps that did not support what they were alleging in their complaint. That would be one example that springs to mind. In this particular case... Is that what Mr. Levine, I mean, in so many words, is that what Mr. Levine's client is? Well, what I mean is the newspaper article... It's a TV report? The newspaper article said 180 degrees the opposite of what was alleged in the complaint. That's what I mean. In this particular case, you have a very, whether or not the news reporter was credible or not, it was a very widely reported story that he was basing his complaint on. And again, this story was credible enough to spark a major law enforcement investigation from 3 different agencies in the Tampa area. The complainant here saw the story apparently and filed this complaint. In my opinion, that is what he should have done in these circumstances.
So at this point, let me just intervene. It's typical for those of us who are lawyers on the commission to want to engage in a legal debate, but both with staff. So we just have to remember that Mr. Schaefer's position here is just to offer an opinion, not to be an advocate for a particular position. So just keep that in mind as he's responding to questions. I'll come back to you, Commissioner Norris. Let me get Mr. Levine.
One comment. I think Mr. Schaefer does a great job. He's got a great teacher over here who's been my friend for a long, long time. I don't know how he knows these facts that I don't know. That I've been standing here dealing with this case now, what, for a year and a half? And he's sitting here and stating facts about a newspaper article triggering a major criminal investigation. That is not what occurred here. There was a major criminal investigation. That's not what brought Mr. Neiman to bring this complaint. So I don't know how Mr. Schaefer knows these things that I don't know. I think I've read everything he has to read. I've got an investigative report. I've dealt with Keith on several occasions about it, and I still don't know these things. But if those things are what he says are true, maybe I should plead those. Maybe I should interlineate the pleadings right now. I think I have a right to move forward to prove my case. If I can't prove my case, I can't prove my case. Sometimes we win, sometimes we lose as lawyers.
Thank you, Mr. Levine. I'm going to give Mr. Schaefer one opportunity to wrap up, and then we're going to move into a discussion of the motion among the commission.
Am I dismissed?
Just hold on one second.
My only response to Mr. Levine, in all due respect, is I'm pulling that from his amended petition. I'm looking at page 5, and where he says that there was an exhaustive investigation done by the Hillsborough County Sheriff's Department and the state attorney, along with the Florida Department of Law Enforcement. So I don't know the specifics of that investigation, but that is where I pull that information from the amended petition itself.
Thank you both, gentlemen. I know we could both probably hear more from you all day, but I think we have a pretty good flavor of both the legal and the factual questions. Thank you for your time. And at this time, I'd ask if there's a motion from the commission.
Madam Chair.
Mr. Cox.
I will move that we approve the order dismissing the amended petition for attorney's fees and costs.
Is there a second?
I'll second that.
It's been moved by Commissioner Cox and seconded by Commissioner Brady to approve the recommended order dismissing the petition for fees. Is there a discussion?
You know, I will say, under discussion, having been a county commissioner, just because something didn't come before the commission for a vote does not mean that the commissioner doesn't have the ability to talk to the county administrator, other senior staff, to project their feelings and their desires of certain things to get done. The fact that it just didn't have a vote before the commission is immaterial. That doesn't mean that you don't use your position to try to push a belief or something that you want to get done forward. So that argument does not ring with me at all. And there's a high bar for this for a reason. And what we don't want to have happen is for people around this state to say, yes, I'm not going to file a complaint because the elected official will use his or her position and the taxpayers' dollars to go after me as a complainant. And that's what's happening here. You know, the other elected officials that were accused of some of these similar allegations that were dismissed, they are not moving forward with this, but Commissioner Hagan is, and he's using the taxpayers' dollars to do it. That's unfair. So I think this is a very clear situation that we need to approve this and move on.
Commissioner Berger.
I just think in looking at it, there are many cases where the advocates recommend no probable cause. There's many cases where we vote no probable cause. And that's why I think we're in the situation on this case where there has to be a good analysis of the case. Not every case out there is going to be an attorney's fees case. And we have to digest the pleadings and the facts to come to this, because otherwise, I agree about there's reasons why the statutes are posed differently. One is on the fining level, 2 is on the fees level. And in this instance, in this case, based upon the facts presented, I agree with the recommendation.
Thank you, Commissioner Berger. Commissioner Norris.
I would simply point out, I don't disagree with anything that my fellow commissioners have just said. I agree completely. Public officials are taxpayers too. We have an equal duty as this commission to the folks who make the complaints as we do to the folks who respond to them. duty is the same. The analysis, under the rule, the code of ethics needs to, apply. So, we are not the trier of fact. This is simply a base sufficiency level decision as to whether or not that case can move forward. Whether or not the particular public official in a particular case chooses to go after multiple, the multiple complainants or just one or whatever, there's all kinds of different factors that may be, that may fall into that. Maybe an analysis of counsel as to, well, this one was malicious, but those weren't. This one meets the standard, those don't. And ultimately, though, just like our executive director makes a facial finding as to whether or not this complaint is sufficient to get the review, that's what we're doing here. Is this sufficient to get the review? He can't prove his case otherwise. He can't get there otherwise. So I'm just looking for some balance on it. I don't know exactly where that is. And so I'm going to vote against the motion. I don't expect my vote to prevail.
Thank you, Commissioner Norris. Commissioner Brady?
I mean, when we look at this process, my sense is that when we have a finding of no probable cause, we in essence provide justice to the respondent, that we have an opportunity to look at what occurs, the investigators investigate the complaint, the advocates develop a recommendation, and we tend to adopt the recommendations that the advocates make. So the justice for the respondent is made when we say, we don't think this happened. There is no reason to believe that this is a violation of the ethics laws. And to really permit people to say, well, gee whiz, I want revenge because this guy embarrassed me, because this guy made me look bad in the eyes of the community, without really an extremely clear, obvious evidence is not the right word, proof that it was done maliciously to really damage someone's reputation. I think we need to set a very high bar in terms of allowing respondents to go back after complaints simply to maintain the fairness of the process. If you think that you can get sued because you made what you think is a legitimate ethics complaint, you're not going to make complaints. And I think we need to be very careful in terms of granting fee requests or granting people to proceed with fee requests unless it is very evident that it was done maliciously with real intent to harm reputations.
Chairman?
Commissioner Norris?
If the legislature determined that justice for the public official was simply a finding of no probable cause, then they wouldn't have the attorney fee provision in the statute. It's there, and it is there for a reason. So that in and of itself is not necessarily justice, and justice, of course, is always going to be in the eye of the beholder, right? So the issue is, has this public official presented a complaint before this commission seeking attorney's fees that pleads the statute elements with specificity? That's the higher standard. And either the commission either says, yes, they have, and if so, then that person is entitled to their quote-unquote day in court as a public official, just like the complainant was entitled to the day in court to bring the complaint in the first place. Or if the commission's answer is no, this doesn't meet the standard, then so be it. That's the vote of the commission. I just think there needs to be a balance, and if you plead, because otherwise, it seems to me we're creating our own standard that I'm not sure how it gets met. Because I keep hearing my fellow commissioners who I have great respect for talking about proof, talking about evidence, not talking about the pleading.
Thank you, Commissioner Norris. Commissioner Cox?
Thank you, Madam Chair. You know, the majority of these complaints, the vast majority of these complaints are brought to us by lay people who believe that a public official may have done something wrong. And the statute is written specifically to cause this next phase for attorneys' fees and costs to rise to the level that they did it maliciously, that they knew that this was an absolute falsehood, that what the complaint that they were doing was malicious and it was full of lies. If you put yourself, for a minute, assume that you are not an attorney that understands the law, that you are just a layperson who sees a news report about an elected official, and that law enforcement finds it potentially grievous enough to do an investigation, to spend resources and energy to do an investigation, not just one law enforcement agency, but I believe 3, to find and in the case that let's go and look at this. They have a different set of standards, so they determine it's not criminal, but is it ethical or not? I think a layperson who files these complaints looks at that and says, you know what, I think it's my public duty to ask that question. Now, if this commission allows those lay people to be put at a disadvantage, then we're creating a big can of worms that should never be opened. You know, as you know, I feel like the complainants should be heard during these hearings, but we take that right away from them as well. So they're at a disadvantage from the second that they sign their name to a complaint. And if you let this go forward, you're doing an injustice. So I'll shut up.
Commissioner Berger.
I just wanted to say that I agree with Commissioner Norris's analysis on the issue involved. But we had 2 different sets of arguments about the pleadings from each side. So I agree with his analysis on the law and what the law is and what we're looking at, but we do need to look at both sides of the argument, and some commissioners may be swayed by one, some may be swayed by the other. I mean, the law is the law, and that's what we're supposed to follow. But at the end of the day, you know, not speaking on any other cases, but this one here, we've heard 2 compelling arguments, both done very well by both sides. And that's really what it comes down to.
Thank you. Anyone else? I'm going to just comment that I am sympathetic to the attorney who represents a public official that is trying to meet this standard and not be able to do the investigation. I am flummoxed, and had we not dismissed or granted other petitions for fees, I would probably think this just couldn't ever be met. But I know we have met it in other circumstances, and that's really what in the end will affect my vote today. Otherwise, you know, I think I agree with and see it the same way as Commissioner Norris. Any other discussion? All those in favor of the motion that recommends adoption of the order dismissing the petition, please indicate by saying aye.
Aye.
Any opposed?
Nay.
The motion passes. Thank you. Thank you, Mr. Levine, Mr. Schaefer, and commissioners for an important discussion about that difficult issue. At this time, we'll move to item 4 on your agenda. This is consideration of final action on pre-probable cause stipulations. We'll take up item 16-123. in re Andrea Young. Will the parties or their counsel please identify themselves for the record?
Melody Hadley, Commission Advocate.
Is there anyone here on behalf of the respondent? No. Thank you. Just to refresh everyone on what we are doing here, after considering all the materials and presentations by Ms. Hadley, the commission may vote to approve or reject the stipulation. As this is a pre-probable cause stipulation, if the stipulation is rejected, we go immediately into the probable cause determination. Ms. Hadley, will you present the stipulation?
At this time, I bring before you a pre-probable cause stipulation. Respondent acknowledged that she failed to accurately file a 2015 CE Form 6 in violation of Article 2, Section 8 Florida Constitution and Section 112.3144. Subsequent to the filing of the ethics complaint, respondent filed amendments for the year 2015. We asked the commission to accept the respondent's stipulation and recommend a total civil penalty of $500.
Are there any questions for the advocate?
Move for approval.
Second.
Commissioner Brady, did you have a question or was that a motion?
Is this in addition to the penalties for not having filed, or this is total penalties?
This is a different issue. This isn't, I'm not positive if there's an issue with her filing or not. This isn't a willful issue. Excuse me, this isn't a willful case. This is just about the content of her form and that there were mistakes in the form.
Filed talent, okay, that's fine.
Thank you. Following that question, I believe I heard a motion and a second. Any other discussion? All those in favor of the adoption of the proposed stipulation, please indicate by saying aye.
Aye.
Any opposed? The stipulation is adopted. The next item is 16-168.
Madam Chairman,
Yes.
I just want to disclose for the record that the public official in this particular case is from Columbia County. It's not the biggest, it is the center of the universe, but it is not the biggest county in the state. And so this is a gentleman that I, know, have a personal acquaintance with and friendship, but not any kind of business relationship. I don't work for the county or anything like that, so I don't think it's anything that creates a voting conflict at all, but certainly is someone that I know.
Thank you for that disclosure, but no conflict there. Any other comments before I ask the advocate to present on the matter involving Russell DePrater? Thank you. You may begin.
Thank you. I'm Elizabeth Miller, advocate for the commission. In this matter, we have a joint stipulated pre-probable cause agreement. The respondent is a member of the Columbia County Commission, and I understand that I may have referred to it as Lake County at some location, and I would like to orally amend that. It is Columbia County. There are 8 allegations. I recommend probable cause on 2 of the 8 allegations. That would be allegation 7 and allegation 8. Allegation 7 is a conflicting employment or contractual relationship. Allegation 8 is a voting conflict. The respondent admits the allegations or the facts that make up allegations 7 and 8. He denies the facts that make up allegations 1 through 6. I have asked for $500 for each allegation for a total of $1,000, along with a public censure and reprimand. Mr. Dietzen represented that his client would pay the total of $1,000 immediately. I would like to point out that if we went to a post-probable cause stipulation, or if we prevailed at a final hearing at DOA, we would obviously ask for more money. I realize that this amount may not be satisfactory. However, I do respectfully ask that you ratify the joint stipulation. Thank you.
Thank you. Any questions for Ms. Miller?
Madam Chair. Ms. Miller referred to that it may not be satisfactory. I'm the one that's not satisfied with that. I look at the prior case that we just had. That was a case where an individual listed that they had an IRA but did not list all the assets inside that IRA. That is a mistake that is made every year at filing time by probably hundreds of people. We find that individual $500 for that. And I think that was an appropriate amount. Quite sure they'll never do it again, and it sends a message to other people. This case, these allegations are much more egregious in my mind. It's where they're using their position for special private gain or loss, and $500 in my mind is not enough when the county commissioner is saying, yes, I did it. They're admitting to that in this, but I just don't think it's enough money.
I understand, sir.
Thank you. Any other comments or questions from the commission for Ms. Miller?
I guess if I may,
Commissioner Berger?
I guess the question would be, how did you come to that number on this case?
We negotiated. It was not what I originally wanted, but that was the amount we negotiated.
Can I ask what you originally wanted?
$1,500 per allegation.
I would support that.
Would you like to support that in the form of a motion, or would
So-
anyone
so-
else like to? Yes. Well,
Commissioner
I realize that he can't.
All you can do is
Stipulate
vote it
that.
up or down.
Yes, I knew that. I was
I'm
just being sarcastic, that I knew that was coming from him, so I'm just.
I was about ready to make a motion.
I'm prepared for him. Anybody else want to make a motion before Commissioner Cox? Go ahead.
I will move that we deny the pre-probable cause joint stipulation.
Is there a second? Hearing none, the motion fails. Is there another motion? Is there a second to the motion to adopt the pre-probable cause stipulation?
Second.
It's been moved and seconded. Is there any discussion? All those in, Commissioner Brady?
Okay. Yeah, I mean, when I read the report of investigation, I was kind of surprised that this had gone to a whatever we call this before, because it did appear that these struck me as somewhat sinister, that I bought land and I knew the land was gonna go someplace, and I sold the land, and I'm on the commission, and I, knew there was a fence company, but I really didn't know, and I asked somebody, and I don't know anymore. I mean, it struck me as not something you would like to get off with $1,000.
Do you want to respond? You do not have to. Actually, it's not even appropriate.
I know,
We have
I
a
know.
motion and a second on the floor. Any other discussion? All those in favor of the motion to adopt the pre-probable cause stipulation, please indicate by saying aye. Any opposed?
All right.
The motion passes.
Thank you very much. I will take your concerns to heart.
The next pre-probable cause stipulation is matter 17-003 in Ray Smith. I believe there's anybody here on behalf of the respondent. Correct? Oh, Mr. Thank you. Ms. Hadley, you may begin.
At this time, we bring before you a pre-probable cause stipulation. Respondent acknowledged that he failed to accurately file a 2014 and 2015 CE Form 6 in violation of Article 2, Section 8 Florida Constitution, and Section 112.3144. Subsequent to the filing of the ethics complaint, respondent filed amendments for 2014 and 2015. We ask the commission to accept the respondent's stipulation and recommend a total civil penalty of $1,750.
Thank you. Mr. Herron, do you have any?
Mark Herron on behalf of Kurt Smith. This proposed penalty is consistent with the other penalties you've done on Form 6 financial disclosures recently, and we would suggest or urge you to adopt the joint stipulation.
Thank you, Mr. Herron. Any questions for Mr. Herron or Ms. Hadley?
Move to adopt.
It's been moved to adopt the proposed pre-probable cause stipulation. Is there a second?
Second.
Any discussion? All those in favor, please indicate by saying aye. Any opposed? Motion passes and the stipulation is adopted. Thank you, Mr. Herron. The next matter is item 17-089 in Ray Reeves. And just to note in your materials that there is a submission from the complainant. The complainants have a right to comment in writing on the proposed stipulation, and that's included in your files. Is there anyone else here? I don't believe so, on behalf of the complainant or respondent. Thank you. Would Mitch Reeves identify? Thank you. Thank you very much. Ms. Hadley.
At this time, we bring before you a pre-probable cause stipulation. Respondent acknowledged that he violated section 112.3137 by having conflict employment with GT Distributors while it was doing business with his agency, the City of Atlantic Beach. There is insufficient evidence to show respondent violated sections 112.3133 by doing business with his agency, or section 112.3143 by voting on a matter in which he received a special private gain or loss. We ask the commission to accept respondent's stipulation that he violated the ethics code and recommend a total civil penalty of $1,000 regarding allegation 2 and dismiss allegations 1 and 3.
Thank you. Any questions for Ms. Hadley? Ms. Bloom?
Good morning, and I'll be brief. I would just request that you guys accept the stipulated consent agreement, and I'm here to answer any questions if you have them.
Thank you. Any questions? Appreciate your being here. Thank you for being here, Mr. Reeves. Is there a motion?
Motion.
Commissioner Berger, I believe, moved to approve the proposed pre-probable cause stipulation. Is there a second? It's been moved and seconded. Any discussion? All those in favor of the motion, please indicate by saying aye. Aye. Any opposed? The motion passes and the stipulation is adopted. Thank you for being here. Comments? The next matter is item 5, matter 16-023 and 16-031 that have been consolidated. This is the attorney's fee petition filed by John Drew seeking fees against complainant Carlos Slay. It was found legally sufficient and sent to the Division of Administrative Hearings. Mr. Drew and Mr. Slay have reached a settlement, and DOA has relinquished the case to our jurisdiction for dismissal. Are either Mr. Drew, Mr. Slay, or their counsel present? Yes, would you please introduce yourself for the record?
Leonard Collins, on behalf of Carlos Slay.
Thank you. Thank you for being here. Do you have anything that you would like to say other than you have this settlement that we have in our materials?
Yeah, well, on behalf of Mr. Slay, actually, I'm very heartened at the discussion that occurred earlier today on a similar type of matter. And we would encourage this commission perhaps to consider a two-way attorney's fee in the future, so that if a complainant is put in the position of having to face someone who's an elected official who's using public funds to prosecute a case against them, if they're successful, they should have an opportunity to recover their attorney's fees, because these attorney's fees in a case like this are very significant.
Thank you.
Sure.
Any questions? Ms. Goss?
Just as a comment, a reciprocal attorney's fees provision has been in the commission's legislative recommendations for at least the last 2 years. So that is something the commission is very interested in, but it takes action by people other than us.
And if you stay long enough, we'll probably have a brief discussion about those people a little bit later. Thank you. Any other comments, or do I hear a motion on the fee petition or the recommended order? It's been moved and seconded to adopt the recommended order. Is there any discussion? All those in favor, please indicate by saying aye.
Aye.
Any opposed? Motion passes, the order is adopted.
So moved.
Thank you. Skipping down to item 7, consideration of probable cause. This is the the probable cause hearing of complaint number 16-148. N. Ray Marnie Retzer, currently Sawicki. It's being heard in our public session because the respondent has waived confidentiality. Is either the respondent or the complainant or their counsel in attendance? Mr. Heron.
Mark Aaron on behalf of Marnie Sawicki.
Thank you, Mr. Heron. Just for the benefit of the commission, the probable cause determination, as you know, is the conclusion of the preliminary investigation. The respondent and the advocate are permitted to make brief statements in the nature of oral argument to the commission based on the investigator's report, the advocate's recommendation, the complaint and staff recommendations, as well as any other written statements submitted by the respondent. But it's important to remember that no other testimony or evidence can be accepted. Ms. Miller, you have
Thank you. Good morning again. Elizabeth Miller, advocate for the commission. Respondent served as the mayor of Cape Coral. She also had a personal relationship with a man by the name of Brian Rist, who owned a company that was a vendor of the city of Cape Coral. The allegations all pertain to her either soliciting or accepting or not reporting gifts that she received from Brian Rist while they were in a personal relationship. The gifts were all jewelry. As far as the other allegations, the condo or renting the condominium and the vehicle were not gifts. The gifts of jewelry were all valued at over $100, and they should have normally been reported on the gift form. However, in this situation, there is an exemption, and that is because the respondent and Mr. Rist were in a relationship, and the respondent, through her attorney, said that she intended to form a household with him, and at some point she did live with him. It appears that the law pertains only to her subjective intent, that they intend to live together in the future, and not based on any other circumstances. For that reason, she did not report or need to report the gifts. As far as the solicitation or acceptance of gifts allegations, there was no evidence that she did either. The evidence is that she accepted these gifts based on the personal relationship. Therefore, for the 4 allegations, I recommend no probable cause. Thank you.
Thank you, Ms. Miller. Any questions for Ms. Miller? Hearing none, Mr. Heron.
Thank you.
Mark Heron on behalf of Marnie Sawicki. Ms. Sawicki would respectfully request that this commission adopt the advocate's recommendation. As you see from the report of investigation, they were involved in a romantic relationship. And again, speaking of those folks down the street who defined relative, they have defined relative to include these types of relationships, and as a consequence, gifts that are given in the context of this relationship are not reportable. The report of investigation also showed that no action was taken by Ms. Sawicki in her capacity as mayor that benefited Mr. Rist's company or his economic interests. In fact, no matters came before the commission while she was in this relationship with Mr. Rist. There was an issue, if you recall, perhaps with respect to him providing money to the city for the 4th of July celebrations, which he did. But again, that was not the type of contractual relationship that is covered by the statutes. And again, we'd ask that you adopt the advocate's recommendation, find no probable cause, and dismiss the complaint.
Thank you. Any questions of Mr. Heron? Thank you, Mr. Heron. Would entertain a motion on this probable cause matter.
Move for approval of advocate's recommendation.
Is there a second?
I'll second that.
It's been moved and seconded to approve the advocate's recommendation. Is there any discussion?
Clarification, advocate's amended recommendation.
Amended recommendation. Thank you. That's accurate.
Yeah.
Any discussion? All those in favor, please indicate by saying aye.
Aye.
Any opposed? The motion passes and the amended recommendation is adopted. Yes, Commissioner Brady.
For the conclusion that there's a relationship between the parties is simply based on their statement?
Is that, who would you like to direct that to?
They say, we're in
Ms.
a
Miller?
romantic relationship, and he gave me a ring, and the recipient of the ring says, oh, yeah, we're in a romantic relationship, and the giver of the ring says, oh, we're in a romantic relationship, and we say, oh, okay, that's fine. I mean, is there any criteria beyond statements of the co-conspirators that indeed is true?
Even though we've taken a vote on this matter, as a courtesy, I'd ask first, Ms. Miller, if you'd like to respond, and second, Mr. Hare.
Those were just.
I mean, it was really.
It was not, yeah.
You don't really think that's
It's clear they lived together. I assume that they had a relationship. But I mean, I just wondered myself, is it simply an assertion that, yeah, we were dating and that's why I gave her the ring and, and it didn't work out.
Ms. Miller, you're off the hook because Ms. Doss volunteered to speak to the process of the investigation and how that's determined. Thank you, Ms. Doss.
Indeed, that question really kind of goes to the process of our investigation, which is where the investigator asks the parties involved. I doubt that in this situation he went around and, polled the neighbors to see if they really did seem happy together. But the law does provide that people who make it known that they intend to make a household together are considered relatives. And if the investigators don't see any reason to doubt the testimony of the people involved, then they typically don't go any farther. If they do see reason to doubt it, then they go further.
Thank you. You're off the hook too, Mr. Heron. Thank you. We'll proceed to matter 17-145 in Ray Doug Underhill. Is there any person present on behalf of the complainant or the respondent? Yes, sir. If you'd introduce yourself for the record, please.
Yes, ma'am. Thank you very much, Mr. Chairman. I am Doug Underhill. I'm the respondent.
Thank you. Anyone else? Thank you. Ms. Hadley, would you make your presentation?
Thank you. Respondent is alleged to have violated Section 112.3136 by requesting that Escambia County Commission approve the payment of his legal expenses from lawsuits pertaining to alleged actions taken in his private capacity. In November 2014, Respondent was elected to the Escambia County Commission after defeating Gene Valentino, who had previously served in that position, and he's defeated him during the 2014 Republican primary. On August 12, 2015, Valentino filed a lawsuit against Respondent for defamation. The lawsuit was dismissed with prejudice on November 19, 2015. On July 7, 2017, Valentino filed a second lawsuit against the Respondent and included Ray Guillory, a candidate in the 2014 Democratic primary, as a defendant. This lawsuit alleges that Respondent and Guillory exchanged text messages in which Respondent defamed Valentino with messages subsequently posted on Facebook. Respondent brought Valentino's second lawsuit to the attention of the county attorney. The county attorney advised that the respondent expressed concern about his ability to pay his legal expenses in defending himself against Valentino's lawsuits. They discussed ways he could deal with the legal expenses. One option discussed was whether Respondent could establish a legal defense fund. Another option was whether the county commission could approve the use of county resources for Respondent's legal defense. As a result of the discussion, the county attorney suggested that they take the issue before the county commission. The county attorney advised that Respondent did not direct this action and that there was no pressure from him to place the matter on the agenda for a county commission meeting. The county policy regarding legal representation states, in part, cases involving current and former county commissioners personally named in any civil, criminal, ethics, administrative, or professional licensing case that arise out of in connection with their scope of county function should be addressed by the Board of County Commissioners on a case-by-case basis. At its September 27, 2017 meeting, the County Commission discussed paying for Respondent's legal expenses associated with the first lawsuit and voted that it was not appropriate. Regarding the second lawsuit, the County Commission voted to seek an opinion from the Florida Attorney General as to whether it was appropriate for the county to pay Respondent's legal expenses. The Attorney General issued an opinion recommending that the County Commission not approve the use of county resources towards respondents' legal expenses. Respondent denied trying to influence the county attorney to take the matter before the County Commission. He maintains that he relied on the county attorney's reliance regarding the Commission's review of the issue of paying his legal expenses. While respondent was seeking a benefit, there's insufficient evidence to show that his actions were taken with a corrupt intent, as he sought the counsel of the county attorney prior to making a request for the payment of his legal expenses. I recommend the finding of no probable cause.
Thank you, Ms. Hadley. Any questions for the applicant? Thank you. Mr. Underhill, you're invited but not obligated to make remarks.
Thank you very much, Madam Chairman, and I'm glad that I'm not sitting up there and having to make determinations about the definition of an intimate relationship. That will not be the case in here. I want to just simply bring up the what is very clearly defined in the findings that were put before you by the investigator, that at no time was there an effort to get taxpayers to pay for legal fees. The entire purpose for bringing all of this to the forefront was to take this practice of politics by litigation out of the shadows and put it in the sunlight. People are often reluctant to do that because of the level of shame that comes with actually standing here in front of an ethics commission and those kinds of things. But it's imperative that as we grow and evolve our society, that we do not create a society in which a vanquished political opponent can then use the mechanisms of government as a weapon against those who the citizens chose to replace him in office. You heard the testimony of 2 lawsuits, both of them now been thrown out. The claimant here is actually a recently retired county commissioner with 20 years of service under this ethics board, knowing full well what ethics is and what ethics is not. And as you can see in the claim itself, the actual claim that former Commissioner Wilson Robertson made is actually a question instead of the very definitive statements of fact that you would expect to see in an ethics complaint. So I would just draw your attention to a couple of very important sentences that were made in the investigation by your investigator. The complaint, therefore, is legally insufficient. The allegation is not sufficient, as there are no factual allegations. So I would ask that you find in keeping with the content of the investigation that was done. And I thank you for the opportunity to bring this forward, because excellence will always invite scrutiny. And so it is an opportunity. It's not, while it certainly feels uncomfortable to be standing here, it's always a great opportunity for an elected official to stand having been fully investigated and to be found to be doing business the right way. So thank you very much.
Thank you, Mr. Underhill. Any questions for the respondent? Thank you for being with us.
Thank you, ma'am.
Taking the journey. There are no other questions. I would entertain a motion regarding the proposed stipulation. It's been moved to approve the stipulation. Is there a second? Any discussion? All those in favor of the motion, please indicate by saying aye.
Aye.
Any opposed? The motion passes and the stipulation is approved. Excuse me? I mean, advocate's recommendation. Thank you. Thank you. Why don't we take a 10-minute break and we'll reconvene at 5 minutes till. Thank you.